I'm Jimmy James.
I'm Carl Knapp.
Carl is a practicing attorney in Montgomery County, Pennsylvania. We're longtime friends, and once a week we get together to talk about divorce, child support, custody, criminal law, and much more. So come hang out, because this is
Just Lawing Around.
What's going on, everybody? Welcome back to the Just Lawing Around podcast. Today we have a special guest. It is a friend and colleague of Carl's, and we're going to let Carl introduce her today. Go ahead, Carl.
Yeah, hi, James. Today we're honored to have Laurie Jubelirer on. Laurie is a practicing attorney in Montgomery County. Her firm is in Plymouth Meeting. She does mostly criminal law, and she also does civil rights litigation. A little bit about Laurie. She's been practicing law for over 30 years. She used to work in the Philadelphia District Attorney's Office for a while. She then also worked as a deputy attorney general in Pennsylvania offices of the Attorney General. She does a lot of criminal trials here in Montgomery County and some of the surrounding counties. We thought she would be a good guest to come on, talk a little bit about criminal practice, criminal procedure, how the whole criminal trial system works. So welcome to the podcast, Laurie. Can you hear us okay?
Yes, thank you. I'm happy to be here.
Good. I guess we could start a little bit. I covered a little bit of your legal background. Anything you wanted to add to that, or we cover it pretty well?
I think you covered it pretty well. Yes. Yes, you have. Mm-hmm.
Yeah. So we're going to talk today about mostly criminal stuff. And I know you handle a lot of criminal stuff for adults and juveniles. What kind of cases is there a type of case that you mostly handle? Like, do you handle all sorts of criminal cases?
I would say I handle pretty much all criminal cases. The only types of cases I don't handle are homicides, but pretty much everything else.
Okay, so you would handle drug cases, gun cases, violent felonies, that kind of stuff? Yes,
that's correct. The whole gamut, in mostly Montgomery County as well as other counties in the southeastern part of the state.
Why not homicides? Is there like a special training for that or something?
That's a good question. When I was in the Philadelphia DA's office, that was my first job, and I was there for 8 years. My training was, my final years there were spent in the major trials unit, and I did not spend time as a prosecutor in the homicide unit. I could easily, if I wanted to, be trained to defend homicide cases. I really just haven't had the experience, and I choose not to right now, for now. So that's
I feel like a case like that would take a big emotional toll on people dealing with those kind of cases.
I agree. And that's another reason the stress of someone's life is more in your hands than other types of cases, because they could face life in prison. And Pennsylvania, there is a death penalty, I believe, but I don't think it's been imposed for a long time. But those kind of consequences puts a lot of pressure on a defense attorney.
Yeah, no, I get that. And the consequences, I think, are just one part of it. I think the other part of it is, when you're defending somebody in that scenario, you're seeing all the evidence. You're seeing videos, you're seeing pictures, you're seeing crime scene stuff. And that's got to take a toll on you as well.
Yes, because and there's the emotions that are on both sides. What the victim's family, the defendant's family, it's tough. I agree.
Yeah, I have no desire. I mean, I have done some criminal defense over the years. I do less and less of it, and actually, I send a lot of my stuff to Laurie because she does a lot more of it than I do. But I have no desire to do a homicide case. I mean, like you said, the emotion and the commitment. I mean, I know you're kind of by yourself in your firm. I know you have a team that works with you, but it's just all encompassing if you do a homicide trial. So
yeah,
I don't blame you.
It is. Yes, it's fine. I have enough stress with the other cases and work, and the consequences are not as severe in the other, even with a major felony.
Right.
So
Right.
Yeah.
And you're not on the, I'm sorry, Carl, you're not on the prosecutor side. You're on the defendant side.
Correct. I defend individuals who are accused of crime.
Right.
In
Okay.
Pennsylvania. That's
Gotcha.
correct. And the other side is always a prosecutor, or sometimes it might be a local prosecutor. There's also occasions when it's the Attorney General's office when there's a conflict. So they act as prosecutors as well.
Okay.
Yeah, and tell us, I guess, a little bit. We've done some podcasts on criminal kind of procedure, but we had talked. I know the process starts, with the filing of a criminal complaint, and then usually next step is you go to a preliminary hearing. Is that right?
Yes, the very first step is a preliminary, like you say, the filing of the complaint and a preliminary arraignment, which happens within a few days of the arrest or the filing of the complaint. And that preliminary arraignment is where they set bail, and where they would either set it such that they would have to be incarcerated or possibly give them conditions and bail that would allow them to be on the street. And then within about 10 days of that is the preliminary hearing, which, yes, that's the first stage of the case, where you're in front of a judge and you hear, and the evidence is presented to see if there's enough evidence to have a trial. And that's in front of in the counties, it's in front of a magistrate judge, and in the Philadelphia, it's in front of a municipal court judge, that stage.
Oh, and that's a pretty low burden at that point, right? At the preliminary hearing, you don't. It's not beyond a reasonable doubt the standard to hold the case.
Correct. It's called more like preponderance of the evidence, or more likely than not. Or actually, it's called not preponderance. I'm sorry. It's prima facie case, which is more likely than not, which is similar to preponderance of the evidence. Meaning, is it more likely than not that a crime was committed and this defendant who's accused committed it? So that's just a way lower standard than beyond a reasonable doubt. Yeah. That's correct.
And I would think, based on the preliminary hearings I've done, the cases are usually held. I mean, it's very rare to see a case dismissed at that level. Is that your experience?
I would say, I'll be honest, and you're right. Most of the cases are held, and I'll be honest that maybe in the counties it might be more held than in the city of Philadelphia, where they're a little more. I would be honest, be a little more liberal, and they might dismiss a case, and they do. The one thing I do want to say in regard to that question is that a couple years ago there was a new law that was decided by the court which did not allow just hearsay evidence alone to be enough for a preliminary hearing to find someone, hold someone over for a trial. So the DA used to be able to rely on, like, for example, a detective saying, hey, the victim said A, B, and C, and they didn't have to bring the victim in. That's crazy. Not allowed anymore.
That's good.
And they have crazy. It is good. It should be that way. Especially if you have a reluctant victim that's not going to ever come in. That's not fair.
Right.
To keep somebody possibly incarcerated for a while and hold them over, have that prima facie case without the victim. So that's been positive. Sometimes, though, if a case is dismissed, the DA may decide to rearrest and start over again, which they can. But
and I've seen that before, right? You hit a home run and the case gets dismissed at the district justice level, and then they just run and refile it, which I think is kind of odd.
I've had that. It's tough. It's a very tough thing to swallow. Yes, that's correct.
They can do that? That's not like a double jeopardy problem? I guess because they weren't convicted?
Correct. That's a good question, because it wasn't a conviction. It wasn't a finding of guilt. Double jeopardy happens when there's a final conviction of guilt.
Right.
So a prima facie case is not. So yes, they can say, we want to get more evidence for the next time, for example. We're going to get that victim in the next time. And they would only do that, honestly, and if it's a serious case. And they may let it go, more likely to just let it go if it's less serious.
So at what point in a criminal matter do you get involved? Is it just whenever your client calls you, or is it, at the preliminary hearing? Like, when do you get involved?
Different stages. That's a good question. It can be the very beginning before the preliminary hearing or even when there's an arrest warrant out for them and they want to turn themselves in. can you help me to turn myself in because it's better that way? Maybe help me get a decent bail so I don't have to stay in jail. Or sometimes someone will hire an attorney and it's not working for them. So they'll call me at a later stage, maybe even at the pretrial stage. Hey, could you represent me? I'm not happy with my attorney, for example. So I just had a recent case. Hey, I'd like to hire you for sentencing. I just won my appeal, and now the Superior Court ordered that I be resentenced. Could you handle my sentencing hearing? So that's the whole gamut, as I've just explained to you.
Right.
When I get hired. Yeah.
Do you sometimes get calls, Laurie, for people that maybe have not been charged yet, but they're getting investigated? You know, the police have called them and said, hey, we'd like you to come in and talk to us. Do you get those calls before anything's ever been filed? People kind of get skittish because the police want to talk to them. Then they call a lawyer?
I have. In fact, I'll try to set up a meeting with me present and the client so if they want to ask them questions, I'll make sure that, whether they should ask, it's in their best interest to answer them. I once had a case where someone called me and thought they were being, like you say, investigated. And then I called the detective and say, I'm representing so-and-so. And then in that case, actually, it happened. I think that the client that was going to hire me, I think they got scared and then I never heard from them again. But yes, I've been through that. And then I actually, when I get those calls, I always tell the detective who's going to speak or investigate my client, please do not speak with them without my presence. And I tell the client, please don't talk to the police without my presence. You have the right to not talk to them. You have the right to say, I don't want to talk to you without my lawyer.
Look, now,
so I always put that in writing or say it.
Right. Carl has strongly drilled into me, don't talk to police. So not that I ever have scenarios where I really need to, but he's always we always have that conversation. So my question for you would be, in what scenario and why would you facilitate questioning from police and be there? And why would you answer anything?
So sometimes, and this is what's coming to my mind right now, sometimes when we're in the middle of a case, let's say we're in the middle and the client's facing pretty serious consequences. Let's say it's jail time.
Okay.
If they're found guilty. And then they may want to, I'm going to use a legal word called proffer. They want to cooperate. They want to proffer. And so if they do that, meaning they know some information that would help the police, that would help the prosecutor. So we'll go in, they might probably be recorded with me, and then they're going to help the police. But then what's going to happen is that those police are going to turn around upon that as cooperation and tell the judge of my client that they cooperated, they helped, they put themselves out there. I have one guy that recently has been involved in being an undercover confidential informant. So when his sentencing comes up, and he was arrested for a large amount of felony drug case, when it comes time for his sentencing, it will be beneficial that he cooperated. That's one example of when you would want, if it's going to work out in their favor, like that.
And that's that scenario on TV when you see him sitting there with a large Coke and a Big Mac and sitting in handcuffs.
Well, yeah.
I don't know what shows you're watching.
Yeah, you may be. I'm not sure about that, but that's one scenario. I mean, there may be other scenarios where they would talk early, but I don't necessarily advise them because they mostly in those situations would end up hurting themselves. Meaning, if they're going to implicate themselves at that early stage, that's always a little dangerous to me.
Right. And in a situation like that, if they don't have somebody like you, and you said something really important, you said that you would generally have that agreement put in writing, where somebody might go in there on their own and do that, not get it put in writing, and cops will just be like, oh, well, he didn't say anything. We just, what I mean?
It's happened. And I just want to bang my head against, the wall. Why did you do that? You needed a lawyer. Why did you talk to them?
Right.
It hurt you. And then I have to deal with the case after that. It's just it's harder to defend that case.
Right.
So,
yeah. And the police, at least some of my experience, police will sometimes say, well, look, if you cooperate, we'll put in the good word with the judge, we'll wink, wink, nudge, nudge. We'll put in a good word. But I don't know what that means, but.
And I have a big problem with that word cooperate because cops think that exercising your right to remain silent to them is equal to not cooperating. And I hate that.
Mm-hmm.
Because
You're
then
right.
they try and punish you.
Absolute right. And then they have a lot of, they've been trained on how to interrogate people, to make them talk. And they sometimes make up lies like, hey, you know, the co-defendant, they implicated you and they're saying it was you and what do you think? And when that might not be true, there's just tricks up their sleeve.
And that's another thing I hate. Like, we could talk about this all day, but cops have no obligation to be honest when they're talking and interrogating. They have no obligation to do that. But if you aren't honest, then that's false statements. That's crazy. You're
right. I mean, there's lots of things that have gone on, and I've had I handle some Philadelphia cases where people are serving life sentences. That's another thing I do, and I've heard some stories, mostly from like the 70s and 80s, where they were beating them up. They were making them stay for hours and hours and threatening their family, and just to solve a homicide. It's really sad, and people have confessed when they really didn't do it because they just were like so. After hours and hours, they were just tired of it.
Right.
So it happens. It does happen.
Yeah.
And I would think as a criminal defense attorney, the sooner you get involved in a case, probably the better, because you can kind of control, make sure there's no missteps by the defendant. You don't want to get in after the defendant has already given a statement, to the police and signed a confession. It's a lot harder to undo things at that point.
I had a jury in August that where that very thing happened. You're right. The earlier I get in, then I can like. I'm thinking of an analogy. Drive the car or drive whatever. I mean,
right. Steer the ship
going the way that I want to. Yeah. So I had a case where a client, before I came on board, he gave a statement to the police with another lawyer, and it really sunk him. Sunk. Where he was supposedly trying to proffer, and it ended up being used against him at his trial, and it was just, he was found guilty, and there was not much I could do. I tried to say, you should believe him today, even though he lied to the detectives a year ago or whatever. And that was hard. So, I got in on his case. I was like his third attorney. So lots of stuff had happened that made his case really hard to defend.
Yeah, and that's tough, trying to clean up somebody else's mess, so to speak.
Yes.
So when you after you get through the preliminary hearing and stuff, you had something about the pretrial. When I know in Montgomery County and I think some of the surrounding counties, you get I think they call it a PTC, a pretrial conference. And when do you get the discovery and stuff in a criminal case? Do they give that to you pretty early on?
It takes a while. I have a lot of cases where I'm sending a lot of emails out and requests. So they're supposed to give it to you. After the preliminary hearing, actually there's something called formal arraignment. That's just where the case goes from the lower court to the common pleas court. You're supposed to, usually once it's at the common pleas court, that's when you get discovery. But oftentimes it takes a while. It may take a few months after the preliminary hearing or after the formal arraignment. And then, like you say, there is a pretrial conference that occurs approximately a few months after the formal arraignment. And usually by then we'll have discovery, or the DA will, because they'll feel the pressure. Well, I'm going to a court hearing. I better get them that discovery, because they won't look so good if they haven't done that.
So I know in a criminal case that you get discovery from the district attorney's office, and I've seen discovery packets. Discovery packets usually will have all the evidence that they have against your client. They're also supposed to provide you with any exculpatory evidence, which is kind of evidence that shows that your client is not guilty. Do you find that the district attorney's office generally give you everything that you're entitled to, or is that something you have to fight for?
In this, I would say it varies, for example, between Philadelphia and at least Montgomery County. Philadelphia is much more willing to give that exculpatory evidence, for example, about police that have been found responsible for certain types of behavior. For example, they've been found that they had beat some people during statements, trying to get a statement from them, or been judges have found them not credible in certain situations. I had a case here in Montgomery County And this was very last minute late discovery where a DA sent me a information and a case where a state trooper had been found liable in a civil rights case where he had been found to have lied on an affidavit of probable cause for a search warrant. So I got that right at the last minute. That type of evidence you really have to kind of be super persistent to ask for. And that was important evidence for me because I tried to be able to use it at trial. I was not successful, but I tried. So you have to really kind of be persistent. They might give you basic discovery, but then persistent on, I need this, and that also. So, yeah.
Yeah, in my experience, and I haven't done as much as you, and I haven't done it in a couple of years. I always found that if it was a traffic stop or something, I would always ask for like the dash cam footage or the body cam footage, and invariably it always seemed like, well, the camera wasn't working that day, right? So you would end up not getting maybe some of the video, and I always was a little suspicious that I wasn't getting that. I guess in today's day and age, you probably get a lot more video and stuff in the discovery packets.
I think it's so much harder to practice today because of technology. There's videos, audios, phone downloads, computer downloads. I mean, so I always have difficulty. They put things on a flash drive. They send it through this special Axon evidence link. So I have to review so much more than the old days before technology. So yes, there's a lot more of that, which actually can help. And I'll just give you an example that's coming to my mind. In a case that I was going to try last week, my client was on electronic monitoring for state parole. And I was able to prove because of that technology that he wasn't at the place where they said he was. It was pretty cool. But
interesting. He had like an ankle monitor.
Super cool. He was on an ankle monitor, so I had to subpoena the record. And I found, and they said he put drugs in this like storage unit. I found that I got the records from the storage unit to show that it wasn't him using the passcode and going in because he was somewhere else 90% of the time. So it ended up, we were going to go to trial and we did a plea deal. They dropped most of all the charges. But that's just an example of the positive of technology. On the other hand, I've had cases where, for example, like a straw gun purchase where they have text, hey, you're going to go get that gun or that John or that Glissy. There's all kinds of jargon for guns. And your client gets sunk. Like, what do you say? It's his phone and his or her phone, and they're saying that, and it's really hard to defend.
Go ahead, James. I thought you had a question because I know James. We talk about the body cam from a lot of the police. Do you find a lot of the police departments have that?
You know what I wish? I'll say what I wish, and then I'll tell you what. Some have it, some don't. I wish there were a state law that required it. We all should have the truth. We all should be able. Let's see what really happened here. And when I don't have the body cam or the dash cam, and usually it's one or the other, I don't. The cops can get away with, I think, some things, some falsities. And when you see the body cam, it is what it is. Here it is. I wish there were a law that required it, but the state troopers do. Pretty much all my state trooper cases have it, but the local police departments, it just varies, and I find it very frustrating.
Carl and I won't go into the details of it because it's kind of ongoing, but we're working on some body camera footage from police for a civil matter with a family member of mine, and I'll tell you what, even when they're working, it's not always easy to get them, the body cam footage. And we're going through that process now of, appealing and judicial review and all that stuff. And it's been a headache and it's crazy. I mean, all fair, I'll go into some more of the details with you, but there's really no reason that it shouldn't be getting released. And it's just, they're hemming us up with the legal process of trying to get it.
You're right. I had one time I had a trooper that they messed up and I had to call all kinds of people where they had it, but it wasn't like saved. It has to be saved within 30 days. So it got destroyed, which I don't get that either. Why should it be destroyed? there should be a law about that too. That's not right.
Well, it should.
There should be.
It should be saved as long as like a statute of limitation or something. Like
something, yeah, like five something exactly. 30
like
days is not it.
If there's a case that comes up 5 years later, you know, and you can still prosecute that case, and that footage should still be available for something like that.
Yeah, you're right. It's the truth. We both sides should want it.
Right.
I agree.
Yeah, and you know, it's so, you know, I think it's so unfair to the defendant that, oh, we didn't save that. Well, you know, that could be critical. Like that could be very critical to his defense. And to say, well, just we didn't save it. And I guess you could argue to the judge, but my feeling is the judges probably say, well, it's gone, get over it.
Right.
There is an instruction you can give to the court. I'm trying to remember. It's called spoliation, and I might be saying it wrong, but there's an instruction of an inference to the judge or jury, whoever's hearing the facts of the case, to say that you can find that against the police that they destroyed this, meaning an inference that there was something on there that would be helpful to the defense. So there is a jury instruction for that, for if they do lose it, not save it, etc.
And and we want to touch a little bit on juries, because you had said the jury charge. Yeah, they instruct the jury at the end of the trial, but like in the beginning of a jury trial, I guess first of all, who has the right to a jury trial? If you say you want one, the DA says they don't. Do you get one as a defense attorney?
We do have the right for one, except for a summary. So a summary offense has a penalty of 90 days or less. For example, what's a summary?
Like a
public
disorderly
drunkenness.
conduct.
That's an example. Public intoxication, I think it's called. That's a summary. You don't have a right to a jury. Now, it's possible. I think you go in front of a magistrate judge for that summary. I think you can appeal it, and then you may be able to get one, but not initially. Every other charge, misdemeanor or felony, you have the right to a jury. So if the defense wants one, even if the DA doesn't, we will get one.
And if you want to waive it, if you say I'm going to waive my jury trial, then the case would be heard by a judge. Can the DA say no, I want a jury?
That's a new law that has been in effect. Like when I first started practice in the 80s, that was not so. The DA didn't have a say. It was only up to the defense, meaning the defense says, I want a judge trial, or the defense says, I want a jury. There is a new, I guess it's part of the rules of criminal procedure, where the DA can request it. I don't know how new it is, but it's kind of new to me.
Yeah, so I vaguely recall
there has been
that
a change.
That was changed. Yeah.
Yeah.
So you could waive a jury, and then it's what's called a bench trial. You just have a trial in front of a judge, or if you get a jury, how do you go about picking the jury? I think a lot of people don't understand how you pick a jury.
Sure. So there's a whole selection process. That's the first part of that happens before the trial begins. And you're in a courtroom with the district attorney, and usually they have they call it the affiant, meaning the police witness who is in charge of the case, the investigator, and then the defense attorney and the defendant. Each side, generally, if there's just one defendant and just one defendant, each side gets 7 peremptory strikes, meaning you can strike 7. There'll be a panel of 50 citizens for example, if it's in Montgomery County, the voters on the voter rolls of Montgomery County would come in. They're called in. They get a summons to come into court to be on a jury, and then all 50 are given they fill out a questionnaire. They're given some instructions by the judge. Each side, the defense and the prosecutor, get a copy of the questionnaire, and then we go into picking the jury. Before we even start that, the judge will call certain people back into their back room. For example, if someone has a hardship, if someone says, I can never be fair, I was a victim of a crime, I just only believe police or something. Right. Then those jurors will be struck for cause, meaning you don't have to use your 7 challenges that you each have. They'll be struck for cause as long as the judge says it allows that. And then
So
after
cause
that
you
happens,
can have unlimited people, that get removed because of cause, and that's because they can't be fair, or maybe they have some, maybe they care for a sick parent or something. They can't sit on a jury panel for a week. And then you get these preemptory challenges, which you can pretty much just strike a potential juror for any reason. Is that how the preemptories work?
it is, except there are limitations, and I'll just give you an example for the prosecutor. There's a case, and I'll think of the name. I think it's Batson. It's a federal case where they're not allowed to strike a juror for racial, based on their race. So if I, as a defense attorney, see a pattern going on by the DA where every time there's, for example, an African-American juror that they strike for their peremptory strikes, I can ask the judge to go in the back, speak to the judge, say, I believe I have a Batson challenge. I believe that they're striking people just based on their race. That's illegal.
Right.
So other than that, you can really pretty much strike for any reason. But I think that's a very good law because, let's say, the defendant in a case is of that same race as the jurors that the DA is striking. That's not fair. They can't just do that for that reason only. And so then the DA would have to come up on the record with an explanation for why they're striking these particular jurors. That's a non-racial reason.
Can a juror have a criminal conviction or any kind of previous summary conviction, citations, or anything like that?
They can, but I'm thinking that because the jurors, that gets into another area of, because the jurors are from the voting rolls, the people who vote, right. I believe, there are certain, and I believe in Pennsylvania, and I don't know it off the top of the law, but there are issues with felons being able to vote.
Right.
So that may be an issue, but no one can, if they're there on a panel and they have a conviction for like DUI or a misdemeanor, if they're there, it should be okay. But there is, and I'd have to look it up, what the law says about people with certain convictions, which I don't agree with at all. I think everybody should have the right to vote, and everyone should have the right to be on a jury.
Right.
But I think there are some limitations.
Sure. Yeah. No, I agree.
Pennsylvania, as well as other states too.
And if I recall, every once in a while I'll get that juror questionnaire. You fill it out, and it gives you a lot of background. I think what you do for a living, where you live, your age, educational background, and I believe it asks you some questions about, would you believe, say, the testimony of a police officer, or would you give it more weight than a normal citizen? Questions like that are like, have you been a victim of a crime? And that's what you get to look at before you decide who you're going to, strike off the panel? It's hard because there's just a basic information about each person. I am married. I am single. I have children. I work at X place. So they do say what their race is. They do say, I don't even know if they say, they don't give their address, I don't think, for us to see anyway. And then they ask those kind of questions. Are you more likely to believe a police officer because they're a police officer? Are you less likely to believe a police officer because they're a police officer? Et cetera, et cetera. Yeah. So it's really hard to size people up and figure will they be a fair juror?
I was just going to say, my mom just got called for the jury panel, and that was the question she asked. And she's somebody that believes, maybe the police would lie just because they're police. And I think that exempted her from being a juror because she didn't have to do it.
Well, they probably struck her.
Yeah.
Somebody struck her for that, probably. Yeah, for sure. But those are the kinds of people I strike. If they're going to, and sometimes they'll bring them in the back for a strike for cause, and then the judge will try to rehabilitate them. Well, do you think you would be fair if I gave you instruction that you're not allowed to consider, you have to treat every witness the same, whether they're a police officer or civilian, and then they'll say yes. But I still have this doubt in my mind thinking, I still don't want them. I don't trust them.
Right.
If they
I mean, I probably would have answered the same way too. So I'll probably never be a juror. I'm not very biased.
Yeah.
And it's probably like, you guys are, you and the DA are looking for different types of people. So the people that you really like are probably the people they don't want on the jury.
True. I want people who are compassionate. I want teachers. I want lawyers. I want social workers. I want people that maybe do have a little record. I want someone who can relate to my client. That's the bottom line. Who can be open. And of course, I want a fair juror, but I definitely want someone maybe who will be leaning towards having a compassionate, fair, and leaning a little bit towards my client.
Sure. Yeah.
That's honestly who I want. Yeah.
Yeah, and Carl asked me earlier if I could ever be a juror, and I know I was just joking around, but at the end of the day, if I was ever a juror, I would be very factual based. Like I wouldn't be just because the cop said this, just because the client said this. Yeah. I would be very like, all right, what are the facts that they actually have? And like, remember, you're affecting somebody's life, so you better make sure you really feel like you're right about this.
I think James would be Laurie's perfect juror. James.
Definitely.
just knowing him and from these podcasts, he would be a perfect juror for a defense attorney.
Sounds like it. Yep. I like attentive jurors too. So I want them real attentive.
Yeah, I'd be very involved. I'd be very paying attention to like every detail for sure.
Yes. So I love it when my last jury, I went to do my closing argument. The best feeling ever is like I'm in front of them doing my closing argument, and I have them shaking their head up and down when I say certain things. I'm like, yes, it's the best feeling
like
ever.
You got them.
They get it. They get it.
Yeah, that's a good feeling. And then you get what do you have? 12 jurors for a criminal case?
12 jurors, 2 alternates.
12 jurors, so 2 alternates.
Yeah, so 2 alternates will leave after the case is over. When the jury goes to deliberate, they will not be needed anymore. But let me tell you, quite often they are needed. Things come up where someone has to be excused in the middle of a trial. Something comes up, and then they're needed.
So the alternates sit through the whole case, and so you really have like 14 people sitting there. But if one of the jurors, gets ill or has a family emergency, then the alternate has already heard the whole case, right? So they just kind of they fill in. Okay.
Yeah.
And then they have to be unanimous. I mean, in terms of guilt or innocence.
Unanimous for guilty, unanimous for not guilty. Because that's correct.
What unanimous means agree. They all agree? Is that?
All 12 must agree. Correct.
Right. Gotcha.
And then they pick a 4-person to lead them in their. One of the 12 will be a 4-person to lead the discussion.
So if one person doesn't agree, that's a dismissal.
Say it again. If one person doesn't agree.
Yeah, then it becomes a dismissed case or like a not guilty or.
It's a hung jury. It's called a mistrial, or another word you might hear is a mistrial.
Okay.
It's a mistrial. It's not all. And the judge was, before it became to that, where one doesn't agree, and the judge would really try to say, go back there and really try to listen to each other and try to come to a unanimous verdict. The judge would give them instructions.
Right. Okay.
And then, but if it's days and days and they just can't do it, it's a hung jury, and then the DA could have to try them all over again, which is not pleasant.
Yeah,
not pleasant for them.
Judges don't want hung juries because it's a colossal waste of time.
It is. Yep.
And you're right. Yeah. Then the DA, there's no double jeopardy that attaches because there's no determination, guilty or not guilty, right? So the DA, I think, normally retries the case. That's usually what happens on a hung jury?
Or it could be negotiations of a possible plea. It depends. But they do. Yeah.
Right.
I've had a long time ago, I had one that was a retrial. It was a hung jury in a retrial.
Now, if your client, depending on what happens at trial, I mean, do you have cases, I guess you have to make a determination as a defense attorney whether your client, who is the defendant, is going to testify. That's probably a fairly big decision that you have to make in each trial. Is that right?
Yeah, it's a hard decision, and there's many factors to be considered with that decision. The one thing I always do, though, is the defendant would be the last to speak. So if the defendant wants to take the witness stand, he or she would be last, so that they get to hear all the evidence, all the witnesses, so they would hopefully be consistent, or, consistent with at least any defense witnesses. The other thing that, one of the big things that I take into consideration is, does my client have a criminal record involving dishonest crimes that they could use against him or her? For example, does my client have a theft charge within the last 10 years? Because if so, a theft conviction, the prosecutor can use that evidence to say to the jury or judge, you shouldn't believe this defendant because they have a conviction for a theft charge, and that possibly you can use that to find them not credible. So that's a big decision. Do I want the jury to find out about my client's record? That's one consideration, and there's many others. Or do I think they'll be a good witness? How do they present themselves? Are they articulate? Do they seem honest? It's a lot of different factors are involved.
And I guess if they had given a statement previously, the DA has access to that statement. So if they testify and there's inconsistencies, the DA is going to jump on that and make the person look like they're lying.
That happened to me in August. Yes, my client took the stand, and then they had this statement that was completely different, and then he had to get up there and explain it, and I'm like, then I had to say, oh, you should believe him today, but he was lying back then. it's not easy. It's
That's the worst.
It's the worst. Yeah.
Oh my God.
Yeah, that's another reason to not give statements to the police.
Yeah.
Exactly.
I got pulled over one time for window tint. I've got pulled over many times for window tint, and I could have a whole argument with you about that. But in the topic of this conversation, I went into court to plead against it, and the officer, one of the questions he asked me in the trial or whatever when I went to court, have you ever been stopped for this before? And I genuinely didn't remember, and I said no. And then they pulled up a record that said, well, here's my officer stopping you 6 years ago for the same thing. And the judge grilled me. I was like, I don't know what I ate for breakfast. I don't remember that.
Yeah, right. Exactly.
Yeah. They're always trying to jam you up on stuff like that for sure.
Yeah.
Well, yeah. And given the statements comes back, but you had mentioned something about somebody's prior criminal record. If the defendant doesn't take the stand, are there circumstances when their criminal history would come in, or is that generally the kind of thing that's excluded because you don't want to poison the mind of the jurors?
It's generally excluded, except there are exceptions. There are rare exceptions. For example, let's say there was this pattern of, similar crimes happening. Maybe my client had been convicted of doing the same exact thing, 2 or 3 times before or something. Then they could show that as not to try to show that pattern in practice, and there's a name for it, and that might not be it, but that it would show that that's how they do their crimes. They do X, Y, and Z. And X, Y, and Z happen in this case. So that's an example, but it's very rare. Usually, like you say, it would poison the jury and they could think, oh gosh, they have a record. I don't like them, and I'm gonna, find them guilty. That's why we safeguard that, and it doesn't come out.
Yeah, and if your client has the absolute right not to testify. Obviously, the DA can't say, "Oh, I'm going to call the defendant, as my witness."
Heck no, that's an absolute constitutional right to remain silent. And no, they can never call the defendant. Now there are situations, like I have one coming up, where the co-defendants can be called against my client. The co-defendants have pled guilty, and they're hoping to help themselves. So they're coming to testify against my client, and that's quite common.
So, and you could probably, as if they testify, then you would have the ability to cross-examine them and ask them if they have made a deal with the DA's office or if they're getting a more lenient sentence. You could ask them those kind of things, right, if they testify?
Absolutely, and it's a lot of fun. I'll just say that word, fun, because they're usually not very credible. They're just trying to save their own skin, and they've already been pled guilty to just whatever it is, and they're not believable. And the only reason they're there to help themselves. That's their motive. So, and it's just not, it's easy to cross-examine them and show they've probably given prior inconsistent statements. They have a motive to lie, and they're not, the juries may not believe them.
Carl, I know you kind of nudged me away from this, but I got to bring it back up because when I mentioned the window tint, I heard a tone in her voice that was like of annoyance, like this is something she's dealt with. And I'm just curious, is that like, what are your thoughts on that?
Oh my God. It's all kind. There's a lot of, I'm going to say it. There's a lot of racial profiling out there.
Yeah.
Driving while black is a thing, and it's very upsetting. I must have half a dozen plus, maybe a dozen cases of minority clients, and often state troopers, local police, oftentimes state troopers, stopping them on the highway for tint or some little minor, your registration sticker is expired. And guess what happens? That little stop for that tint or minor insurance sticker thing turns into this full-blown canine car search, aggressive search.
Yeah.
It's and I see, honestly, I see a lot of racial stuff going on where, again, they're not stopping me, and they're stopping my minority clients.
No, I totally agree with that.
It saddens me, and it saddens me what I see. And in Philadelphia, they just, I don't know if you've read this or heard it, but they are, I guess I'll say the word, I don't know if the right word is outlawing, but maybe that's the right word, outlawing those kind of stops. They say, you are not, local Philadelphia cops, no, you're not going to stop people just for that. That's not. I
did hear about that,
okay
about
anymore.
like petty things
because
like that.
Because too much you see the people being stopped are majority Hispanic, African American, other minorities, and it's not okay. That's not okay.
And what I always found interesting is when somebody's being stopped for window tint, I would bet 80% of the time the cop pulling them over has blacked out tint all the way around the car.
Yeah, I don't get it. Like, why don't they focus their energy on other things? Why?
And I guess it's just it's kind of a ruse to stop the vehicle and start talking about questioning the driver and asking the driver.
Oh, you're nervous. I can search your car. That's what they do. He exhibited signs of nervousness. That was probable cause to search the car. Of course he's nervous. Who wouldn't be nervous?
Yeah.
The police just stopped me. No matter what, it's scary. And some of them have been on probation and have records, and it is scary.
Right.
Well, and they might even be acting suspiciously, Laurie. And you know when people act suspiciously, that's a problem. The police love to say he was acting suspiciously.
Suspiciously, right. And my experience of 25 years as a trooper, I've seen this behavior many times, and it's indicative of a crime occurring.
Right.
It's like,
suspicious isn't a crime, so.
No,
I know James wants to ask about the dog. It's the canine.
I had one like that. The tinted windows, the registration sticker, then the canine, and it was like, yeah.
I got an unbelievable story for you about that. When I first got my license, I was 18, so it was 2008. I was at the mall, my girlfriend and we came out to the car, and at the time I smoked cigarettes. I don't smoke cigarettes anymore, but at the time I did, and I left a half a cigarette in my ashtray, and when I went to grab it, I dropped it. So my girlfriend and I were both looking down like the center console, like trying to find it and get it, and a cop must have seen me do that. So as I back out of the parking spot and I drive off, I get pulled over, and the cop says, well, I have a witness who says that they saw you getting heroin out of the center console of your car. I'm like, are you crazy? Like, I've never done drugs. I don't do drugs. So he uses that. He takes my ID and everything, runs my name and everything. He ends up giving me my ID back and saying, we have a canine coming. We want to search the car. I said, well, you can't search the car. No. I said, all right, we'll have a dog come. So the dog comes, they sniff the car. The dog bites my license plate and like bends it in half. And then they say that that's him indicating. So they end up towing my car, getting a warrant to search it, and find nothing, but tore my car apart. And all of this happened for no reason. There was nothing in the car. It blew my mind.
Yep. common. I mean, it really is.
At one point, somebody told me that when the cop gave me my ID back, that I was no longer in a detention with him and I could have just driven off. Is that true?
It depends. You'd have to say, am I free to go? I mean, I don't know. Did they tell you were free to go?
I don't recall.
It sounds like you weren't because they got a search warrant and towed the car.
Yeah, well, they got it. Yeah, because the dog apparently hit on something, and I never had drugs in my car. I don't do that kind of stuff. It was crazy to me though that happened.
Yeah, it is really sad.
Yeah,
really
and the dogs.
Very,
I mean,
very common.
Is that just discretion? Like if they pull me over and they go, "Hey, you got to stay here because we're going to get the dog," or do they have to have some sort of
probable cause for the dog?
Do they got a probable cause for the dog?
That's a search.
I mean, is his testimony, in my case, his testimony of, well, somebody said they saw you getting heroin, is that probable cause?
I mean, could that be construed a little more? How the heck does someone know what they saw?
That's what I'm
doing
saying
in the console,
right?
You know,
right.
That's like a little iffy to me.
It was insane to me because I've never associated with drugs, never had. I don't even know what heroin looks like, and for them to say that, I was like, what? Is this really happening? Like.
And how could they even see it with all that window tint you have?
I didn't have any. I didn't have any on that car. I should have.
They can't even see in the vehicle. That could be your defense.
I know, right?
Look at all this. Look at this illegal tint I have.
For that.
Right. Well, I got. There was another time I got pulled over for window tint. I'd say probably 7 or 8 times, and there was a time where I drove past the police with all my front windows down. And he pulled me over and said that you have window tint on your front windows. My first question was, well, how do you know that my windows were down? And he got all like upset. Wow, who are you questioning me? And he actually reached his hand in my car and pushed my window button to raise the window up. And I got furious. I was like, you are not allowed to just come in my car and do that. That's illegal. I got the tail end of it on video, but I didn't actually get that action on video. And that was infuriating to me because driving by with my windows down and him not seeing that invalidates his stop because he said he stopped me for window tint. Well, how would you know that if the windows were down?
And they can see inside. That's the whole point. They can see.
Right.
The windows are down.
Right. It was crazy to me.
And I think, you know, when Laurie talks about, you know, profiling, the kind of car you drove, James, I think was a big reason that you got pulled over.
I mean, that's true.
There are certain cars, I'm sure, that they pull over more frequently than others. They would never acknowledge that. I have window tint. I've never been pulled over.
I mean, cars that look more expensive with window tint, I feel like don't get bothered, you know, like a Cadillac. You're probably less likely to get pulled over in a Cadillac.
It is. I get so many of these cases. It just is. I just know.
Yeah.
Do you get a lot of people that consent to the search, the vehicle search, when the police pull them over and they go, "Hey, we want to search your car"? Do you get a lot of clients that say yes? Yeah.
They feel intimidated. They don't know that they can say no.
Right.
They don't understand that they have the right to say no, and often it's not explained to them.
Right.
So it's not really. I had a client that they searched him, his person, and didn't find anything, and they supposedly asked him again, "Can I check you again?" Like, no, you don't even have probable cause. Like,
oh my gosh.
Yeah. The people are very intimidated. Even people with experience, they don't understand that. I think that's a big thing that people need to be, I guess, educate people that they can say no.
Well, that's part of the reason we started this podcast, was to start educating people, you know, with their rights with their kids and family law, the rights with divorce and criminal, and just start spreading the awareness of like what they're allowed to do. Because me and Carl say all the time, 9 times out of 10, people talk themselves into handcuffs.
Yes, often. Correct. I get these cases, I'm like, why did you do this? Why did you say this? Yeah. Oh, you didn't have to. You could have said no.
Yeah, exactly.
They don't know.
We are coming up on that hour mark, so if there's anything either you guys want to get in now, we can close out with that.
Yeah, I'm just going to ask a quick question. I'll finish with this, Laurie, because we kind of went through the whole jury thing, and then the jury comes back. It's either guilty or not guilty, and then I guess if it's guilty, you can file an appeal to that. To I guess it goes to Superior Court. Is that right?
That's correct. There's 30. You can file a motion in front of the judge after your sentence. Usually, you would appeal after sentencing. So you would get convicted, and the judge would sentence you. Usually, it takes a few months to get sentenced. They would look into your background, and then you can appeal. You can ask for a motion to reconsider a sentence, and if that doesn't go well, you can appeal to Superior Court. And depending on what there are certain errors occurred at trial, or if the sentence was excessive, and other things as well. Yes, absolute right to appeal.
And then if you're found not guilty, that's the DA can't appeal that. That's
Correct.
It. That's the end of the case.
The very end. Client is completely acquitted. That case is over. Can't retry someone twice because of it.
Then double jeopardy would attach at that point. They can't retry them. And that's the ultimate goal from your standpoint, right? Get that not guilty.
It's not so easy, I'll be honest with you. It feels good, especially when it's supposed to. Some cases you don't think it's going to happen. It's a really tough case, and you're doing your best, but it's probably going to be a guilty. But when it happens, and it's supposed to happen, there's nothing like that feeling when justice happens. It's just wonderful. I've done my job, and justice occurred. It's wonderful, and it's rare, unfortunately, but it's when you. It's just a great feeling when you've worked so hard for that and it happens.
Right.
Yeah. And the system worked the way it's supposed to work, which is refreshing.
Yeah.
All right. Well, that's gonna wrap up the podcast for today. Laurie, thank you for joining us.
Thank you. I enjoyed it. Appreciate it.
Absolutely. We hope to have you back. I know there's a lot of things I want to get into with you, but
if you guys anytime.
If you guys are looking to hire an attorney, you guys want to set up a consultation with Carl, all his information is at the end. If you guys are interested in setting up something with Laurie, you can reach out to Carl as well, and he can send you over to her, and you guys can set something up, and hopefully we see you guys on the next podcast. The information contained in this podcast is provided for general information purposes only. It is not intended as legal advice or advice for a specific case or legal matter. Nothing in this podcast should be construed as an agreement for legal representation. This podcast and parties do not represent you in your particular matter unless there's an express written representation agreement between you and this firm. If you're interested in obtaining legal services, head over to cnaplaw.com or call 215-268-6333 and schedule an appointment today. That's cnaplaw.com. 215-268-6333. For more high-quality music like this, head over to bensounds.com.